Gentleman's time has expired. With that, we go to the gentleman from Minnesota. Mr. Ellison is recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member. Ms. Wu, allow me to ask you about a bill called the TRID Improvement Act. You familiar with it?
Yes, it's one of the bills before this hearing, the committee on this hearing.
Do you know of examples of homebuyers paying strange and unexpected fees as part of their closing costs?
Oh, absolutely. We've even seen examples of a fee to email documents.
And do you know of examples of homebuyers being referred by a retailer to a title agent, a lender, home warranty service, et cetera, that provide a kickback, an affiliation, or some kind of financial benefit for the referral?
Kickbacks are certainly an issue, and I don't have case citations, but I believe the CFPB and before that HUD had taken action against settlement service providers for kickbacks.
How likely is it that a homebuyer will find out about these overcharges, referral fees, kickbacks?
The ordinary home buyer, it's probably very hard for them to figure that out.
So it's pretty rare.
Rarely, yeah.
Hard to discover and rare to be discovered.
Yeah.
So let's say someone gets a mortgage and finds out later that the lender also charged them for property insurance or life insurance or opened up a bank account or credit card in their name without their permission. What would happen under current law?
Well, it depends on the type of charge. I mean, in some cases they might be entitled to a refund, some cases actual damages, other cases statutory damages, other cases no remedies.
And what would happen if there was an accounting mistake in the closing disclosure form?
Well, so right now the situation is that once the error is discovered by the creditor or the regulator, they have 60 days to fix it. And if they fix it in 60 days, there's actually no liability.
Okay. And under current law, how would the error get discovered? Would it be the borrower, the regulator, through a lawsuit?
It could be any of those.
Most likely avenue?
Just any of them,
vary.
yeah.
And if a lender found an error, what penalties would they pay? Out-of-pocket costs to the borrower, a fine? What would be their hit?
So if they fix it within 60 days, there are none of that. After the 60 days, then yeah, there could be refunds or penalties.
Right. So under the proposed TRID Improvement Act before us today, the error correction time frame is expanded from 60 days from discovery, 2 months, to 210 days, 7 months. Am I reading the bill right?
Yeah, I mean, that's our reading of the bill too, and it's a significant extension of that time period.
So if a lender makes a mistake or an error under the bill before us today, lenders will have 7 months to correct it without any liability, is that right?
7 months, yeah.
In my read of the text of the bill, the language is designed to prevent any administrative action by the Consumer Financial Protection Bureau. This bill gives the creditor the ability to simply say, oops, after being caught or not having any penalty for making that mistake.
Yeah.
Is that right? And am I right that under this bill, any penalty assessed for errors is limited to out-of-pocket costs for the borrower?
Yeah.
And so in other words, if you get caught by fleecing a consumer, you wouldn't have to put the money you take to, you could get away with it, essentially.
It certainly gives less incentive for the lender to fix things and to fix it quickly.
So let me ask you how this 7-month review time interacts with a 1-year oversight period for the Real Estate Resettlement Procedures Act, or RESPA. Does giving the creditors or assignees 210 days instead of 60 days to run out the clock on the 365 days to pursue RESPA violations?
So I'm assuming you're talking about the statute of limitations, and yeah, so what would happen is, there would be 7 months for the lender to fix the error, and then a much shorter time period, 5 months between the end of that and the running of the statute of limitations when you couldn't file a lawsuit after.
Right. So in light of what you shared about overcharges, kickbacks, and stuff like that, should we keep the pressure on lenders to regularly review their work for errors and correct mistakes?
Absolutely.
Should we reduce the pressure on them to be excellent and honest in the work that they do?
No, I mean, incentives, as we've learned, being a consumer advocate for 15 years is very important. And that's why things like the penalties or the statutory and actual damages are important both in RESPA as well as the Fair Credit Reporting Act. You reduce punitive damages, you reduce statutory damages, you increase these periods for cure, and you reduce incentives to get it right.
So I'm not in favor of the bill because I think it's bad for consumers, and I think the power and the authority and the reason to know how to get it right is really on the lender. So I plan to oppose it. Thank you for your testimony. I think I'm over time.
Thank you.
Jumping yields back. With that, we